Hi, my name's Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case Till versus SCS Credit Corp. This case was heard in the Supreme Court of the United States, the year 2004. Let's go ahead and jump into the facts of the case. So the Tills are debtors. They got a little too underwater on their payments, and they had to file for bankruptcy. So the Tills filed for Chapter 13 bankruptcy. This is known as the payment plan chapter of consumer bankruptcy. So to understand Chapter 13, we need to know a little bit about Chapter 7. Chapter 7 is what you would think of when you normally think of bankruptcy. That is saying, I have so much debt that I basically can't go on anymore. I'm going to give the court and all of my creditors all the property that I have and that I'm able to give up, minus some exemptions, exempt property. And then the court is going to give that to all of my creditors, and I'm going to walk away and not have to pay any of my creditors. So that's Chapter 7. That's what we know. Now, Chapter 13 bankruptcy is a little bit different. You still have a lot of debt, but you're coming to the court and you're going to say, court, I want to file for bankruptcy, but I still think that I can pay my creditors something. I'm going to pay them on a payment plan from 3 to 5 years. So that's what this Chapter 13 bankruptcy is. Now, there's a few important pieces of a Chapter 13 bankruptcy. One, you have to get your plan confirmed. So the judge has to say, yeah, you know what, this payment plan is good. We're going to let this person file this Chapter 13 bankruptcy, and if they make all of the payments on their payment plan until the end of the 5-year window, then they're going to be discharged. They don't have to pay any of their debts beyond that, right? So in a Chapter 13 bankruptcy, you can hold on to your secured property. So if you have a home that's secured by a mortgage, you can hold on to that. If you have a car that's secured by a car note, you can hold on to that. And so that's precisely what's issue in this case. The Tills have a car that is secured by SCS's car loan. SCS has a car note on the loan for $4,800. So this $4,800 note secures this truck that the Tills own. The Tills own this truck, and it's worth $4,000. So this truck is underwater, we might say. The value of the car is less than the value of the loan. So the Tills come into bankruptcy and they want to cram down this car loan. So the cram down is a type of process wherein you would discharge any amount that you owe over the value of your car. So the Tills are going to come into this Chapter 13 bankruptcy. They're going to get a hang on to their truck, and they're going to get a say, hey, you know what, SCS, sorry, see you later on that $800, and we're going to discharge that in a Chapter 13 bankruptcy. We're going to cram down the car loan, and we're only going to pay you $4,000, and we're going to pay you that amount over the next 3 to 5 years. So that is how the cram down essentially works, right? Now, what's at issue in this case is what rate of interest should be used on that cram down value. Okay, so this seems really convoluted all of a sudden. So we have a $4,000 vehicle, right? That's what the Tills are going to have to pay. But on top of that, the Tills are going to have to pay some type of an interest rate, right? Because they're going to get this car today. They're going to get the value of the car today. Let's say filing bankruptcy day 1. And then 5 years from now, it's going to be paid off. And so if SCS were only to get paid $4,000, that wouldn't be fair to SCS, right? Because there is this thing called time value of money. And the longer we go on, the value in the truck one goes down, but the value of the dollar gets less and less and less. And so we have an interest rate to kind of account for this. And that's what we know in most lending. When you get money for a car or for a house, you have to pay interest rates. So the Tills were subprime lenders. So the Tills had a 21% interest rate, which just seems massive, right? That is a huge interest rate. And so SCS comes into this bankruptcy and they say, yeah, we want the $4,000, but we want the 21% interest rate over the 5 years of the plan. Well, that's going to make this a lot more expensive for the Tills. And so the Tills argue, no, we want the prime interest rate. At this time, that was 8%. What is the prime interest rate? Well, it's the interest rate that the Fed sets at what they say loaning money should go at, right? You should loan money at 3% right now, 3.25, I believe what it is. Back in 2003, 2004, it was 8%. And so there's this dispute before the court where there's a circuit split. Certain circuits have treated it as we're going to let the debtor discharge the deficiency, so the $800 in the Tills case, and then we're not going to make them pay the 21% interest rate, which is what they owed under the contract of their car loan. We're going to allow them to pay the 8%, the prime plus interest rate. So the dispute is, under our bankruptcy law, what should we force the debtor to pay? The Congress wasn't all that clear on the statute, whether it was the contract interest rate or the prime interest rate. It just says present value. And so what is present value? Is it the contract interest rate or is it the prime plus rate? And ultimately, a plurality of the court, so we don't get a majority of the court here, says that it is the prime plus interest rate. Justice Stevens writes for Justice Ginsburg, Justice Souter, and Justice Breyer. And these four justices essentially say, you know what? This debtor has come into bankruptcy. They are not so much of a risk as defaulting on their loan anymore. And so this 21% interest rate is just kind of obscene. We're going to allow them to cram it down and get that prime interest rate. This is a great ruling for debtors. This is fantastic for debtors because you can come into a Chapter 13 now and, like the Tills, get rid of an excess of 13% interest rate, which can really add up over 3 to 5 years, and you're going to get the prime interest rate. A few reasons, but the main reason kind of behind this is these debtors are not much of a risk of default anymore, right? The trustee is administering their payment plan, and so the risk of default isn't that huge anymore to allow a lender to get a 21% interest rate, something that is so large. And there's also just kind of this undertone throughout the plurality's opinion that bankruptcy is about forgiveness. It's about a fresh start. And if we're going to impose these crazy interest rates, these crazy high subprime interest rates on these consumer debtors that are, even faithfully coming into a Chapter 13 most of the time and trying to, pay their creditors what they can, well, let's forgive them a little bit. Let's give them this lower interest rate and dial it back. And they say that is, essentially more accurate. They kind of look at it as, you are starting a new car loan. Once you file bankruptcy, we're starting you with a new car loan going forward rather than looking back at that contract interest rate. Justice Thomas writes his concurrence, which is very close to the plurality's opinion, and so that's why we kind of have this prime plus rate is what is going to govern secured property in Chapter 13 bankruptcies. And before I move into the dissent, I just want to note something that's important. This cram down, where you move to the prime interest rate, does not work on your principal residence. So that's something to remember. You can only cram down on, cars, second homes, other secured properties, and reduce that interest rate. But on your principal residence, your primary residence, you cannot reduce that interest rate. So something to think about. Now let's move into the dissent. Justice Scalia writes for Justice O'Connor and Chief Justice Justice Roberts. And they say, the contract interest rate is a much better indicator of the risk that these debtors are to these creditors. They don't look at this as the formation of a new loan. They look at this as kind of the continuance of one loan that's kind of slightly being modified through bankruptcy. They don't doubt that you can discharge the deficiency. So in the Tills case, $800. But what they do doubt is that the interest rate should be, an additional, or it should be crammed down 13%. They say the contract interest rate should be the presumption, and the judges can then vary from that presumption bit by bit by bit to try and account for the individual scenarios of each debtor, whether that secured property is going to go down, it's more likely that it's depreciating quickly, whether there's less likelihood that the debtor is going to be able to repay under the plan. There is this slight variation. And that variation does take place in both aspects. That's why it's called the prime plus. You can have that 0 to 3% variation under the majority's opinion. And there's also this variation under the dissent's opinion. There's this interesting, ultimately they're saying, Justice Scalia is, that there's still a high chance that these debtors are going to default in a Chapter 13 bankruptcy. There's still a high chance, a high likelihood that they're not going to make it to the end of this yellow brick road and get that ultimate discharge. Yes, they have to make their payments faithfully for 3 to 5 years. And these debtors are already struggling when they come into Chapter 13. And, there's arguments, and they threw statistics back and forth in the oral argument about, 2 out of every 3 make it to the end of the road, and 1 out of every 3 does not. And so there's still this great risk of default here. And it's kind of a creditor's rights opinion where it's saying, yeah, there's this contract that's going to govern throughout, and yeah, we have to look out for the creditors as well. The debtors have gotten a sweet deal. They were able to cram down $800, and let's let the contract interest rate govern. It is more accurate is kind of the key conclusion there. It's going to be more accurate of the risk of default than a prime plus is. So that's the decision. It's a really interesting thing to think about. What should we have debtors pay in bankruptcy? Should we have them pay the prime plus formula or the contract interest rate? And you can see great arguments on both sides. I think that's why this one ended up in a plurality and not in a majority. So thanks so much for watching. Hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.